I would like to welcome you to Hinshaw's 25th Annual Labor and Employment Seminar. We have a great program planned for you today. The information presented today is not intended to and does not constitute legal advice, recommendations, or counseling under any circumstance. You should not act or rely on any information provided without seeking the advice of an attorney licensed to practice in your jurisdiction for your particular situation. In addition, the information presented during this session does not necessarily reflect the opinions of our clients. Again, thank you all for joining us. Let's get started. It is my pleasure to welcome today's presenters, Andrew Gordon and Concepcion Connie Montoya. Andrew is a partner with Hinshaw & Culbertson and a litigator who focuses his practice in the representation of management side labor and employment matters, such as defending employers against state and federal discrimination, sex harassment, wage and hour, and retaliation claims, as well as FLSA collective actions, DOL compliance audits, whistleblower claims, OSHA investigations, and litigating non-compete trade secret issues. Andrew has represented large and small employers through all stages of litigation. He also advises employers on a range of HR policy and compliance issues and conducts on-site management and employee training. Connie is also a partner with Hinshaw & Culbertson and brings nearly 2 decades of experience to her trial and litigation practice in employment law. Connie counsels her clients on a variety of employment issues, focusing on discrimination and harassment matters, including claims related to discrimination on the basis of ethnicity, gender, age, pregnancy, and disability. She has defended employment claims before the federal and state courts, as well as administrative and governmental agencies, including the Equal Employment Opportunity Commission, in connection with claims brought pursuant to Title VII, as well as those arising from the Fair Labor Standards Act, the Age Discrimination in Employment Act, and the Trafficking Victims Protection Act. She also defends claims involving the Americans with Disabilities Act, arising from alleged public accommodation and website accommodation violations. All right, Andrew.
Thank you for that great introduction, Tara. We appreciate it. And thank you all for joining us today. Before Connie and I get into our presentation, we want to let you know that the PowerPoint you're about to see was put together by Hinshaw attorneys from coast to coast. It was a real team effort. And right now, our employment law practice group is putting on this very same presentation for our West Coast clients, our Midwest clients, and our East Coast clients. Since those of you here today are on the East Coast, from Florida to New York, what Connie and I are going to do is focus on the topics we believe are of the most interest to you. So if either of us quickly fly through a particular topic, like some wacky case from the 9th Circuit Court of Appeals out in California, it's because we have a feeling there's other topics that are of more interest to you, and we want to make sure we have time to really dive into those today. In other words, we're going to try to focus on the East Coast meat and potatoes, and for you vegetarians and vegans out there, I guess that would be the equivalent of tofu and broccoli. Sound good? All right, great, let's get going. The first topic Connie and I are going to cover is the most interesting and very important labor and employment decisions that came out of the Supreme Court this year. Our first case is Comcast Corporation versus National Association of African American Owned Media. In this case, the Supreme Court addressed the standard to use when assessing claims under Section 1981, which is a federal law that creates a cause of action for individuals claiming intentional race discrimination. Now, I know we don't see many employment law claims filed under Section 1981 compared to those we see filed under Title VII, but they do occasionally pop up from time to time, which is why we're covering this case today. But for causation, just very briefly, and as a reminder, requires a plaintiff to prove that but for the existence of a certain fact, for instance, such as race, the plaintiff would not have been subjected to some complained of adverse treatment. Here, in a unanimous decision, which is pretty rare these days from the Supreme Court, Comcast prevailed when they refused to contract with an African American owned media network because Comcast was able to show that race wasn't the underlying factor in making their decision. Rather, it was because the network didn't bring in as many viewers as compared to other networks. So in other words, the plaintiff could not prove that race was the only factor that Comcast considered, if it was actually considered at all, in not doing business with this particular media network. This is why we always tell our clients to document the legitimate business reason or reasons for taking an adverse employment decision. Documenting the reason or reasons for taking an adverse employment action against an employee will help prove why you in fact took the necessary action and not leave anything up to interpretation. So I can't stress this enough, and I'll say it a few times today. Document, document, document. Our second case is Babb versus Wilkie. Now this case only applies to federal employers. I don't believe we have any federal employers attending our East Coast presentation, so we're gonna quickly go through this case. For federal employees over 40 years old who allege age discrimination claims under the ADEA, the court now applies the more lenient motivating factor test when determining if age discrimination took place. The motivating factor test, as you know, makes it much easier for an employee to show that his or her employer should be found liable for discrimination. This is because all the employee has to do under this test is show that age was at least one of the factors, even if it was just one of many, that led to the adverse employment decision. Now contrast this with the but-for test we just talked about, and you can see how the hurdle is much lower for employees when the motivating factor test is applied as opposed to the but-for test. But keep in mind, again, this decision only applies to federal employees, not private employees. So private employees still bear the higher burden of proving that age was the but-for factor or the only factor when alleging age discrimination claims. Connie, over to you.
Thank you, Andrew. So we move into COVID, and of course, the Supreme Court continued to do its work. And in the middle of the pandemic, one of the landmark decisions to date by the US Supreme Court was issued under Bostock versus Clayton County, Georgia on June 15, 2020. This is the biggest employment decision by the Supreme Court with respect to LGBTQ+ employees. The ruling culminated 70 years of struggle and activism seeking statutory protection for sexual minorities against employment discrimination. In essence, the Supreme Court extended Title VII protections to sexual orientation and gender identity, which are not protected categories under the language of Title VII. And prior to this day, there was very little federal protection, if at all, to LGBTQ+ employees. The Bostock case is really three cases filed under one. And just to give you a little bit of background, Bostock, which came out of Georgia, Bostock is a gay man who worked as a child services coordinator. He received positive performance reviews and numerous accolades in his employment. He participated in a gay recreational softball league in 2013 outside his work. His colleagues, when they found out, began openly disparaging him based on statements about his sexual orientation and identity. And then he was terminated for conduct unbecoming of employees. In New York, the second case is Zarda, which came up all the way before the Second Circuit, and it involves an openly gay diving instructor. And he was fired by his employer, Altitude Express, after the boyfriend of a female customer complained that Zarda came out to his girlfriend before a tandem skydive. And the reason Zarda did that was because he was going to strap himself physically closely to the female skydiver. and he wanted her to feel comfortable. But a complaint ensued because he came out, and he was terminated thereafter. The third case is the Harris case. Amy Harris was a funeral home employee who had presented herself as male. Subsequently, she wrote to her employer, the Harris Funeral Homes Group, so that they could be prepared for her decision to undergo gender reassignment surgery, and telling them after the vacation that she planned to return dressed in female attire that otherwise followed the employee handbook. She was fired shortly after the letter was sent. So these cases came up all the way to the Supreme Court, again under Title VII, because at that time, Title VII does not, and it still does not have an protected category based on sexual orientation and gender identity. And surprisingly, and in a close decision too, the Supreme Court sided with the employees and extended those protections. So today, we highly urge you to look at your employment handbooks, manuals, policies. We also ask you to avail of trainings specifically for gender and sensitivity in the workplace, gender inclusiveness in the workplace, and so that you could properly follow the law. Now, there's a couple of loopholes here in the Bostock decision. This decision does not affect hiring people as non-employee independent contractors. It also doesn't apply to the military, I believe. Another question that the Bostock decision leaves open is with respect to religious rights, specifically under the Religious Freedom Restoration Act. Under RFRA, as it's commonly known, which applies to religious organizations and for-profit companies that have a religious owner or board, the employer can terminate an employee based on a religious belief of the organization. So they may, in other words, they may make decisions based on faith. And that is an issue, although it was argued under Bostock, was never fully addressed by the Supreme Court. And we believe that the next line of cases coming up will open up this issue. Another decision with respect to religion and employment came up in July, almost a month later, before the Supreme Court, and that's Our Lady of Guadalupe School versus Morrison Berry. And in a 7-2 decision, the majority opinion was written by Justice Alito, the court essentially said, narrowed the employment protections to secular school teachers in religious schools. This was the application of the ministerial exception. Typically, or before this decision, the ministerial exception bars ministers, specifically, ministers from suing churches and other religious institutions for employment discrimination. But this time, the Supreme Court extended it to lay school teachers because they played a key role in teaching religion to their students. The court's decision makes clear that a variety of factors and not a fixed formula may be important to the analysis of whether an employee performed religious duties when allowing an employer to use the First Amendment to shield it from employment discrimination claims. So those are the 4 major decisions by the Supreme Court in this year, and I'm sure more are coming. And moving on, a little bit outside SCOTUS is another decision we'd like to address today, which involves the Equal Pay Act. But this is a Ninth Circuit case, and it is not a Supreme Court case. In this case, just for a quick background, the plaintiff worked again for the County of Fresno, had 2 master's degrees. And this came up because she believed that notwithstanding her qualifications, her male colleagues made more than her. Now, the trial court denied the employer's summary judgment, noting that prior salary alone can never qualify but in and of itself as a factor other than sex. In the appeal, the Ninth Circuit held that prior salary cannot be the sole justification to explain a difference between men and women, or why women specifically made less than men. Now, interestingly enough, one of the Ninth Circuit judges died before the opinion was issued. So when it came up to the Supreme Court remanded it due to the death of the appellate judge. So it came back down before the Ninth Circuit in February, and the appellate court maintained its prior decision and basically said it's setting wages based on prior pay risks, perpetuating the history of sex-based wage discrimination, which goes against the Equal Pay Act. The Equal Pay Act, as you know, was eradicated in order to equalize the pay, the salaries and wages between men and women for the same positions and same experience. The Ninth Circuit joins the 10th and 11th Circuit. However, the 7th and 8th Circuit differed in that respect. So if you come into defending claims before the pursuant to the Equal Pay Act, you should really look at the decisions in the circuit and where you're at, given the divide. The other case that we have, which we also felt was worth noting, is a religious accommodation case that was filed before the Western District of Wisconsin. That's Eeoc versus Walmart. And this is interesting because it gives employers a sort of a benchmark into what is passable, what is acceptable accommodation, reasonable accommodation, or when an employee brings forward, requests a reasonable accommodation based on their religious practices or religious beliefs. In this case, the assistant manager received an offer of employment to work at a 24-hour Walmart store, and but the assistant manager was required to work on weekends. And the potential employee advised that they could not work on Saturdays due to their religious belief. Walmart withdrew that offer of employment, but offered the candidate a non-managerial position, as well as the assistance of HR in his job search. The candidate filed suit, and essentially the district court came back and found on behalf of the employer, on the basis that Walmart had provided or had offered a reasonable accommodation, and that accommodating on one hand, and on the other hand, accommodating the candidate's request would have resulted in undue hardship. So this is, we flagged this case for you in order for you, when you start thinking about providing reasonable accommodations to employees, to help guide you in making decisions and in considering options that you may provide to either an existing employee or a potential candidate. And with that, we move to the next big topic of our update of our presentation today. And I turn to my colleague Andrew, who will talk about the federal paid leave laws.
For CLE credit, the first two digits of the code are going to be LE, as in labor and employment. So LE. Thank you.
Okay, next up, we are going to cover families first. This is a big one. In this section, we're going to get into the nitty-gritty of the Families First Coronavirus Relief Act, which I'm going to refer to today as Families First. As I'm sure everyone attending this seminar knows, Families First was a massive piece of federal legislation that was passed by Congress toward the beginning of the COVID-19 pandemic here in the US. Families First was meant to assist business owners and employees in dealing with the real life fallout associated with various COVID-19 related issues impacting employees in their personal lives. Families First created 2 types of leave to help workers affected by COVID-19. The first is the Emergency Paid Sick Leave Act, which provides eligible employees up to 2 weeks of paid sick leave. And the second is the Emergency Family and Medical Leave Expansion Act, which amends the Family and Medical Leave Act to provide eligible employees up to 12 weeks of family and medical leave, 10 of which are paid. Both acts delineate the specific reasons related to COVID-19 for which leave may be taken. And before we get into this section, I want to point out that we're going to be focusing on the various changes and evolution associated with this law, and to emphasize how much this law is constantly in flux and has been since its passage. I want to share a quick anecdote that proves how confusing and frustrating this law has been for employers and employees, despite the fact that it is certainly assisting in saving jobs, which we can all agree is a good thing. When this piece of legislation first came out, it was essentially an unfunded mandate. And no one likes to hear the term unfunded mandate, especially business owners. Employers saw that they were about to be forced to pay for their employees to not work and wondered how on earth this made any sense. How were they going to cover these costs when they didn't have much revenue, and in some cases, no revenue whatsoever coming in? It just didn't make any sense. So a lot of employers started laying off employees rather than being forced to comply with this new law that they wouldn't be able to comply with. Only then did the Department of Labor and Treasury Department all of a sudden realize that this law, without funding from the federal government, just didn't add up. So the Department of Labor and Treasury Department issued guidance stating that all employer costs associated with implementing this program would be covered by the federal government on the back end by a dollar-for-dollar payroll tax credit to employers. But by then, tens of thousands, if not hundreds of thousands of employees had already been let go. So again, I'm using this as just one example of the craziness we've all been dealing with these last few months when it comes to interpreting and implementing the various massive pieces of legislation coming out of DC. Okay, so let's do a quick overview of Families First. As previously mentioned, under Families First, there are 2 different types of leave: emergency paid sick leave and emergency FMLA. And for each one of these forms of leave, there are 3 big things to remember. Under emergency paid sick leave, you got to remember that employees are allowed up to 80 hours of paid leave for their first 10 days. There are 6 reasons for taking emergency paid sick leave, and I'm going to highlight those on our next slide. And calculating an employee's pay while on emergency paid sick leave depends on the reasons why the employee is taking leave in the first place. And we'll go over that in just a couple minutes. The 3 things to remember with emergency FMLA leave. Emergency FMLA leave provides up to 12 weeks of leave with the first 2 weeks being unpaid. And there's only one reason for taking emergency FMLA leave, and that's because an employee's child's place of school or care is closed. That's it. And employees are paid for weeks 3 through 12 at 2/3 their amount of pay, which is subject to certain caps that we'll cover in a minute. Let's go over the 6 qualifying reasons that trigger an employee's right to take emergency paid sick leave. And here they are on your screen. The first one, an employee may take emergency paid sick leave if that employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. Second, has been advised by a healthcare provider to self-quarantine related to COVID-19. Third, is experiencing COVID-19 symptoms and is seeking a medical diagnosis. Fourth, is caring for an individual subject to an order described in number 1 above, or self-quarantining as described in number 2 above. 5, is caring for a child whose school or place of care is closed for reasons related to COVID-19. or 6 is experiencing any other substantially similar conditions specified by the Secretary of Health and Human Services in consultation with Secretaries of Labor and Treasury. Okay, so those are your 6 reasons. Again, we're going to make reference to these 6 reasons later on when we're talking about how to calculate an employee's rate of pay while on emergency paid sick leave. So it's important to make sure you're familiar with these 6 reasons so you get your calculation correct. When taking emergency paid sick leave, again, we have to look at the reason why the employee is taking leave in the first place to determine how pay must be calculated. If an employee is eligible for emergency paid sick leave due to his or her own inability to work, which would be reasons 1 through 3, the employer must compensate that employee for any paid sick leave he or she takes at the higher of the employee's average regular rate, the federal minimum wage or the local minimum wage. However, this is capped at $511 per day or $5,110 in the aggregate. For employees who are absent from work to care for others, which would be reasons 4 through 6 that we covered a minute ago, employers must compensate them for any paid sick time they take at 2/3 their average regular rate of pay. However, this is also capped, and the cap for this form of pay is $200 per day or $2,000 in the aggregate. As mentioned earlier, there is only one qualifying reason for an employee to take emergency FMLA leave, and that is if the employee's child's school or place of care is closed or the child care provider for that employee's child is unavailable due to a public health emergency. That's it. A lot of employers don't realize it's really this simple when it comes to emergency FMLA leave, but there's one reason and one reason only. So our next question is going to be whether emergency FMLA leave is paid or unpaid, and it's actually both. The first 2 weeks of emergency FMLA leave, usually 10 days, are unpaid. During this time, the employee could take emergency paid sick leave or other PTO to substitute for the first 2 weeks of unpaid leave. The last 10 weeks of leave are paid at 2/3 of the employee's average rate of pay over the last 6 months, but again, capped at a statutory rate of $200 per day and $10,000 in total. An employer may choose to pay more on top of this capped rate, but tax credits are limited to the statutorily capped rate. It's important to note, emergency FMLA leave is just another form of FMLA leave and is lumped together with all other forms of leave. So an employee gets a total of 12 weeks in the aggregate. Any FMLA leave an employee has already taken in the employer's FMLA year reduces the amount of leave the employee can take during that same FMLA year. In addition, any amount of emergency FMLA leave an employee uses will reduce the amount of FMLA leave an employee can take for other reasons during that same applicable FMLA year. But it's important to keep in mind, as we're going to talk about briefly on the next slide, both emergency FMLA leave and emergency paid sick leave are not going to last forever. It's important to remember that the Emergency Family Medical and Leave Expansion Act is in effect from April 2nd, 2020 until December 31st, 2020. Now, it's possible Congress could extend this period, but for now, that's the effective period, and that's it. So you essentially have 2 more months that this very big piece of massive legislation is in effect and that you need to worry about. But again, we will be on the lookout for a possible expansion from Congress. Under the Emergency Family and Medical Leave Expansion Act, any individual employed by the employer for at least 30 days may take up to 12 weeks of job protected care, and that's important to note. Again, it's job protected leave to care for the employee's child if the child's school or place of care is closed or the child care provider is unavailable due to a public health emergency. And this is another issue that's been popping up a lot recently with students going back to school. The Department of Labor has provided clarification on when a child's school is closed for COVID-19 reasons. So for instance, if your child has signed up for remote learning when your child's school offers an in-person option, you're actually not eligible to take paid leave because the school is not technically closed. And you can find that in the DOL's frequently asked questions website at question number 99. Surprisingly, the DOL has done a great job on this specific issue and given us a black and white answer. Also related to going back to school, if your child has an alternating schedule, for example, in-person classes Monday, Wednesday, Friday, then distance learning on Tuesday and Thursday, the school is considered closed on Tuesdays and Thursdays, meaning that employee would not be eligible for leave under the Families First Act. That again is answered on the DOL's frequently asked questions website at question number 98, and it's pretty clear, which is a relief these days coming from the Department of Labor. Okay, on our next slide, I'm going to point out to you again that just like the Emergency FMLA Act, the Emergency Paid Sick Leave Act is only in effect from April 2nd until December 31st of this year. Again, this could be extended, but for now, we have 2 more months of this act being in effect and for employers to need to be on the lookout for these forms of leave. Eligible employees for emergency paid sick leave are those who have been employed by a covered employer for at least 30 days. Unlike emergency FMLA leave, there's no requirement that employees must work a certain amount of calendar days to be eligible. Paid sick leave under the Emergency Paid Sick Leave Act is in addition to your employee's other leave entitlements. You may not require your employee to use provided or accrued paid vacation, personal, medical, or sick leave before paid sick leave, and that's important to point out. And the DOL in their frequently asked questions website at question number 15 stresses that regardless of whether you grant or deny a request for paid sick leave or expanded FMLA leave, you must document the following: the name of your employee requesting the leave, the dates for which leave is requested, the reason for leave, and a statement from the employee that he or she is unable to work because of the stated reason for needing leave in the first place. On our next slide, we're going to talk about what businesses are covered by Families First. And I think, Tara, if you could push back one slide. Thank you. Okay, remember, Families First only applies to employers with less than 500 employees, which in the US is a whole lot of employers. Certainly a lot of big businesses out there that are not covered by Families First, but there are many, many more that are. This includes all full-time and part-time employees, regardless of how long the employee has been employed with your organization. It also includes those employees who are on leave, as well as any other temporary or other individuals for whom you would be considered a joint employer. So in other words, the net is being cast pretty wide on this definition of employer for purposes of Families First. However, only employees working in the US or a US territory count toward that employer count. Employers should count their employees when the employee's leave is to be taken. And this is important. So this means if an employer is hovering around 500 employees, it will need to keep a close watch on its employee count, particularly when an employee makes a request for leave and when that leave is going to be taken to determine if at that time the employer has 500 or less employees. And it's also important to point out here that Families First exempts 2 additional groups of employees: those who qualify as healthcare providers and employers with fewer than 50 employees. And we're going to get into that in a little more detail now. If you recall, we discussed a few slides ago that employees could be denied emergency paid sick leave. One of the reasons is if an employer has less than 50 employees and the request is made due to the need to care for a son or daughter due to the closure of a school or childcare. A common misconception that we're seeing a lot is that employers with less than 50 employees believe they can deny all families first emergency paid sick leave request. And that's just not true. If you have less than 50 employees, you may be eligible for the small business exemption, which allows you to deny leave, but only when it's due to the need to care for a son or a daughter due to the closure of that son or daughter's school or childcare facility. If leave is requested under any of the other qualifying reasons for emergency paid sick leave, then an employer with less than 50 employees has to grant the paid sick leave. For example, if your employee was experiencing COVID symptoms and sought a medical diagnosis, they would be eligible for paid sick leave, despite the fact that you have 50 or less employees. But it's important to note that in order for a small business to make a denial for emergency paid sick leave, it must meet the requirements of section 826.40 subsection B, which we're going to cover right now. Here are the requirements for this section in order for a small business to justify and sustain its exemption. The leave would result in the expenses and financial obligations exceeding available business revenues and cause the business to cease operating at minimal capacity. The absence of the employee would entail a substantial risk to the financial health or operational capacities of the business because of their specialized skill, knowledge, or responsibilities. Or there are insufficient workers able, willing, and qualified who will be available at the time and place needed to perform the services provided by the employee requesting leave. And these services are needed for the business to operate at minimal capacity. So a few important notes relating to this determination process. Employers must document that a determination has been made pursuant to the criteria we just covered, and employers must retain that documentation. It's not enough, for instance, for a small business owner to do this analysis in his or her head. It needs to be written down somewhere and documented. Again, document, document, document. However, as strange as it sounds, the Department of Labor has emphasized that small businesses utilizing this exemption should not send any supporting materials or documentation to the Department of Labor when making a denial, but rather they should retain the documents for their own files. So therefore, upon determining that one of the three scenarios above applies, we would recommend documenting in some form or fashion how and why you arrived at that conclusion and simply retaining those documents for your own records. And regardless of whether or not a small business qualifies under this exemption, you're still required to post notice. And logically, that's because there's only one way of the 6 ways that a small business can say they're denying emergency paid sick leave. There's still 5 other reasons that force small businesses to pay emergency paid sick leave. So the notice must still be posted. Connie's now going to tell us a bit more about the case from New York that's resulted in a number of important changes to Families First that we're going to cover in a couple minutes.
Well, understandably so, Andrew. When the federal government came out with the Families First, it really created a lot of confusion, a lot more uncertainty. The document they issued was huge. The guidance was ambiguous at many places. Terms were conflicting. And so the New York Attorney General's office took it upon themselves to immediately challenge the new law. Not so much on the employer side, but really on behalf of the employees. In particular, the AG's office believed that there were so many other provisions that left a lot of New Yorkers vulnerable. So they filed suit in April before the Southern District of New York. And right around August, the first week of August, the Southern District Court came down and and struck down several parts of Families First. And now here we are on a whole new other landscape, redefining Families First. Andrew, I turn it back to you to explain what those are.
Okay, thanks, Connie. And listen, I love New York, but I'm sure glad I live and work here in Florida, because things down here, at least from an employment law standpoint, are much more straightforward and easy. But in its revised rule, the Department of Labor clarifies what they mean by permitting Families First leave to employees who are unable to work or telework because of a specific COVID-19 related circumstance. Unable to work does not mean the employer does not have work for the employee. The court in the state of New York versus US Department of Labor held this definition was too broad and that it could mean anything. So what the Department of Labor did was clarify that the term leave is understood to mean an authorized absence from work if an employee is not expected or required to work, he or she is taking leave. So for example, if an employee was already off of work because the business was temporarily closed or because the business is permanently closed and the employee has a qualifying reason to take leave, that reason is not the cause of the employee's inability to work. If the employee is already off of work, this would lead to absurd results. So while the Department of Labor revised its reasoning for the work availability requirement, it stands by the logical idea that the employee still must be expected or required to work in order to take leave. They also advise that furloughed or temporarily laid off employees are more appropriately directed to contact their unemployment agency rather than seek leave from their employer that has furloughed them or temporarily laid them off. Again, a pretty logical conclusion when you think about it. One of the conclusions that I do not believe is as logical is the revision to the healthcare provider definition. So the Emergency Family Medical Leave Act and the Emergency Paid Sick Leave both provide that an employer may elect to exclude an employee who is a healthcare provider or emergency responder from the benefits provided under the statutes. So prior to the DOL's recent revisions to the definition of healthcare provider, the rule provided a broad definition and included anyone employed at a hospital, nursing facility, retirement home, nursing home, healthcare provider, or similar institution, employer, or entity. It also included anyone that the highest official of a state determines as a healthcare provider necessary for the response required to the COVID-19 pandemic. Now, the revised regulations define healthcare provider a little more literally. Instead of looking at the operations of a business in terms of whether the business provides healthcare, the revised regulations look at the individual employees and what services those individual employees provide. So the revised regulation breaks down healthcare provider into two groups. And again, this was a big 180 for the Department of Labor. And for a long period of time, healthcare provider was defined one way and people relied on that definition. And then all of a sudden it was completely revised to mean something else. So the first group is anyone who is a licensed doctor of medicine, nurse practitioner, or the like. And the second group considers any person who is employed to provide diagnostic services, preventative services, etc. And the regulations also provide examples of employees who used to be considered healthcare providers, but now are no longer considered healthcare providers, such as someone in HR, IT, or the billing department, which again, under the previous definition, would be someone involved in the providing of healthcare, but under the new, more literal definition, these individuals are not healthcare providers. So in summary, the new definition focuses a whole lot more on the scope of an individual's job duties rather than characterizing the employer as a whole as a healthcare provider. The next change we saw as a result of the case out of New York relates to intermittent leave. And not much has really changed here. Intermittent leave can still only be taken with an employer's approval. Employees must take paid leave or expanded family and medical leave intermittently while teleworking for any reasons under emergency paid sick leave or emergency FMLA leave, provided you and the employee agree to a set schedule. So employees who report to their work site may take intermittent leave with their employer's consent only if they are taking leave to care for their child whose school or place of care is closed, or whose child care provider is unavailable because of a COVID-19 related reason. When the employee is reporting to their work site, this is the only qualifying reason for intermittent leave and can only be taken intermittently if the employer consents. So what happens when an employee requests intermittent leave to care for their child due to a hybrid school schedule? Well, intermittent leave exists only when the employee is taking partial day increments of Family's First leave. So an employee who is taking Family's First leave in full day increments to care for children whose schools are operating on alternative day basis are not considered to be taking intermittent leave. Next up, we're going to talk about notice procedures relating to Families First. Previously, Families First required employees to provide notice and documents for taking Families First leave prior to actually taking the leave. But we can all agree there are a lot of circumstances where that's just not practically possible. So the court in State of New York versus USDOL struck down this rule, reasoning again that there are a lot of circumstances where this is not possible. Now employers can require employees to provide documentation supporting their need for paid sick leave after the first workday of the leave period. An employer can require documentation supporting the need to take leave under emergency FMLA as soon as practically possible, which again is a pretty reasonable conclusion. So for example, if an employee learns on Monday morning before work that his or her child's school is going to be closed on Tuesday due to COVID-19 related reasons, the employee must notify his or her employer as soon as possible. That's it, pretty simple. If the need for emergency FMLA leave was not foreseeable, for instance, which is happening a lot during this pandemic, and if that employee learns of the school's closure on a Tuesday after reporting for work, the employee may begin to take leave without giving prior notice, but must still give notice as soon as practically possible. Again, a pretty reasonable conclusion here by the Department of Labor. Now we're going to hear from Connie about some specific New York and Massachusetts leave laws.
Thank you, Andrew. So in the interest of time, I will just briefly touch upon these two laws because we still have a couple of things, major issues to cover. But keep in mind what Andrew said. Families First will expire on December 31st, and it may be extended. But in the meantime, in the Northeast area, keep in mind about New York and Massachusetts in particular, who have enacted or amended their existing paid sick leave laws, which will, although it's in effect now, employees are not able to take advantage of them until January 1 of 2021. And in effect, what's remarkable under New York law is now the employers are required to provide 40 to 56 hours of paid leave per year. And that applies to all employers, private and nonprofit employees, regardless of industry, occupation, employment status, meaning part-time, full-time, seasonal, or overtime exempt status. Employers are going to be required to provide paid sick leave. Also, one thing to note that if you have out-of-state employers, must provide this paid sick leave if their employees physically work in New York State. In the age of COVID, arguably that may extend to employees who provide services in New York State. For Massachusetts, a similar law was also taken effect, although I think it's a little bit more generous than what New York has provided. This takes effect also in January 1 of 2021, up to 12 weeks of paid family leave. So it's like the FMLA, the difference being is that this is paid leave, and this does not replace FMLA, by the way, and 20 weeks of paid medical leave. The key thing here is that employers and employees are required to contribute to the program, which began last year in October, and again, this applies to all types of employers. The leave laws are very confusing. It's very important that you consult with counsel with respect to the interplay of federal, state, and even local leave laws, especially during this time, and we're all working from home, and a lot of new laws are coming in effect. So just a quick touch on the EEOC, big agency, affects all of our lives, both as employers and as employment attorneys. A big update on the EEOC is with respect to the opioid use and accommodation. This is new guidance issued by the EEOC, and essentially it states that employers dealing with opioid use in the workplace have the right to assess whether the use is pursuant to a prescription, is a medically based assisted treatment program, in determining how to go about handling requests from employees for reasonable accommodation. So in other words, employees lawfully taking opioids because they have a prescription are entitled to a reasonable accommodation claim. Otherwise, an employer who does not go into the reasonable accommodation dialogue or provide reasonable accommodation ultimately may be open to an ADA claim. That is the American with Disabilities Act. Now, similarly, another issue comes up when you mention opioids. You also think of medical marijuana. Now, interestingly enough, although the EEOC has issued guidance on the use of opioid, it has remained silent on medical marijuana. Will that change? Most likely, I would think, given the trend. But currently, keep in mind at the moment that the current federal illegal status of marijuana means that patients who use medical marijuana are not protected under the ADA, even when state law authorizes the use of the drug for medicinal purposes. So keep in mind that while you may get some protection under the ADA when it comes to issues of the use of medical marijuana in the workplace, you have to really look at state law as well. As you all know, that claims are not just made pursuant to federal law, but also made pursuant to state law. So, for example, there's a couple of states who regulate the use, prohibit employers rather from making employment decisions or rescinding job offers or for employees testing positive for marijuana, again, depending on the use of marijuana. Those states include Alaska, Arkansas, Connecticut, Delaware, Pennsylvania, Rhode Island. Also be mindful of local laws. For example, in New York City, you cannot test beginning May of this year. Employers can no longer test for marijuana use with respect to potential employees. We cannot talk about the EEOC without touching upon COVID and employee screenings. Keep in mind, the EEOC has approved that employers may conduct temperature checks, maintain logs of those temperature checks, monitor for COVID symptoms, and may require symptomatic or potentially exposed employees to remain at home. So while COVID testing for COVID is protected, antibody testing is not. So it's because it's not deemed sufficiently accurate or reliable to meet the ADA exams of employees. Keep other statutes in mind. For example, Genetic Information Non-Discrimination Act prohibits employers from asking employees about medical questions about family members. So keep that in mind. However, GINA, or this statute in its acronym, does not prohibit an employer from asking employees whether they had contact with anyone diagnosed with COVID-19. And last but not least, when it comes to ADA and EEOC and COVID testing, keep privacy laws in mind. Keep HIPAA in mind. Any logs maintained are considered confidential health records under the ADA and must be handled as such. I'm turning over now to you, Andrew. We are a few minutes shy of the top of the hour. And we still have another 1 or 2 more major updates, but we will try to be as brief as possible, being respectful of your time. Andrew?
Second CLE code is 1-2. And I'll share the final code in a few minutes.
Thanks, Connie. Next up, we're going to go through 4 quick updates out of the DOL this year that are non-COVID-19 related. So the first we're going to cover is the DOL issuing new FMLA forms. Somehow they found the time to issue new model notice and certification FMLA forms. I don't know how they found time to do that, but they did. So employers covered by the FMLA are obligated to provide their employees with certain critical notices about the FMLA, so both the employees and the employer have a shared understanding of their obligations. There's no new content to these forms. Essentially, what the DOL has done here has caught up to the 21st century, and they've made these forms a little more user-friendly, which is nice to see. So for the most part, when you start perusing some of these new forms, I think you're going to see that, again, these are much easier to use than the old forms, and they're much more in line with other forms that your business is probably using with your employees. Next up, we'll quickly talk about some proposed changes the DOL has put out there for independent contractor and employee classification issues. And again, I want to be real clear, these are just proposed changes, but these changes could affect future classifications for independent contractors and employees. So I'm sure we're all very familiar with the existing DOL fact sheet number 13, which lists the 7 factors that courts have traditionally considered significant in determining whether someone's an independent contractor or employee. This proposed rule would replace fact sheet number 13 and would replace it with 2 core factors that you can see up there on the PowerPoint and 3 general guidepost factors for determining classification of independent contractors and employees. It's important to note that the DOL is emphasizing that the 2 core factors are going to be given more weight than the other guidepost factors, as these 2 core factors help determine if a worker is economically dependent on someone else's business. So keep that in mind when you're looking at these new factors. But again, this is just proposed, so it's something to keep an eye on. These regulations are not going to go into effect, if at all, until after the DOL reviews the submitted comments and published as a final rule. So again, nothing's changed on this front, but it's definitely something we all want to keep an eye on this year. Fluctuating work week. In a big win for employers, the Department of Labor has found that through an opinion letter that was issued, that fluctuating work week can be used almost across the board for employees, even if their hours are not always above 40 hours a week. Again, though used far less often than the typical time and a half method for overtime payment, employers' use of the fluctuating work week may increase, for example, upon employees' gradual return to the workforce and employers' issuance of modified work schedules during the ramp up that we're going to see, hopefully coming out of this pandemic soon. So using this method for salaried employees who work overtime typically results in a rather large savings to employers when calculating overtime payments. So we're happy to see the DOL saying that this method is appropriate. Next up, the salary basis update. Pretty simple here, effective as of January 1st, 2020. The threshold salary basis for executive, administrative, and professional employees under the FLSA has increased to $684 a week, $35,568 per year. So that's a good increase. It obviously benefits employees more, but this increase is more in line with the economic realities of today and is meant to be a fair deal for employees. Highly compensated employees have gone from $100,000 a year to $107,000 a year. So if you haven't made adjustments yet when it comes to your salaried employees, in order to make sure that you're at the threshold where you want to be, now is the time to do so. So Connie's now going to cover very quickly the last section of today's presentation, which is our NLRB update.
Thank you, Andrew. And the more common, and we picked this topic for you because we know that a lot of our clients, employers always grapple with the issue of joint employer. So most recently, the NLRB finalized its joint employment rule that came out of the Browning Ferries Industries of California versus the NLRB. Basically, this case, which dated back in 2015, decided in 2018, and was only finalized only a few months ago in February, earlier this year. The importance of this is that the Browning Ferries case overruled the joint employment standards. It overruled cases holding that an entity must exercise direct and immediate control over the essential terms and conditions of employment of another entity's employees in order to be considered a joint employer. The new rule now, what the board held was that indirect control or unexercised contractually reserved control alone could be enough. The Court of Appeals held that unexercised reserved control and indirect control can be relevant factors in determining whether the entity is a joint employer. So this basically opens up the question of whether an entity can be held as a joint employer away from direct control to more of an indirect control. So those factors are going to be looked at. And really briefly, I am going to talk a little bit about what really direct and immediate control is. And that means with respect to wages, if an entity exercises direct and immediate control over wages, if it actually determines the wage rates, salary, or other rate of pay that is paid to another employer's individual employees or job classifications. With respect to benefits, so we go from wages to benefits. Keep going, please, on the slides. Keep going. When you go under benefits, an entity exercise direct and immediate control over benefits if it actually determines the fringe benefits to be provided or offered to another employer's employees. So you go from wages, next one is benefits, and number 3 is hours of work. An entity exercises direct and immediate control if an entity determines the work schedules or the work hours, including overtime, of another employer's employees. And another factor is hiring. When an entity determines which particular employees will be hired and which employees will not be hired, that may be deemed as direct and immediate control. So keep those 4 things in mind. That's wages, benefits, hours of work, and hiring. And last but not least is discharge. If an entity decides to terminate the employment of another employer's employee, that is also a factor of direct and immediate control. We cannot talk about discharge without mentioning discipline. Again, if the entity decides to suspend or otherwise discipline another employer's employee, that is another indication of joint employment, as well as supervision. And this means actually instructing another employer's employees on how to perform their work, or by actually issuing employee performance appraisals. So keep that in mind, especially when you're working on employment manuals, if you have contracts with other employers and your contracts indicate that certain tasks must be done a certain way, or certain discipline must be done a certain way, or supervision must be done a certain way, that may open up the issue of whether the entity you're contracting with could be considered a joint employer. Again, hand in hand with supervision is direction, assigning particular employees individual work schedules, positions, and tasks. So substantial direct and immediate control means it must be regular, it must be continued, and has a regular or continuous consequential effect on essential term or condition of employment of another employer's employees. So that's the direct control factors. And really briefly on the indirect control means, indirect control means basically indirect control over essential terms and conditions of employment, but not control or influence over setting the objectives, basic ground rules, or expectations for another entity's performance under a contract. And the other prong of that is the contractually reserved authority, means the authority that an entity reserves to itself under the terms of a contract with another employer over the essential terms and conditions of employment of that other employer's employees. This is, again, this frequently comes up in the context of, for example, service agreements, master service agreements, and there are portions of those contracts that may talk about how the workforce of the other entity may be controlled, supervised, influenced directly or indirectly by the other contracting party. So keep all of that in mind. I'm going to head over now to you, Andrew, for a Q&A, should there be anyone, and I mean any questions. You're on mute. Go ahead.
Tara, have we seen any questions pop up during the presentation?
There are no questions.
Okay, so great. With there being no questions currently, I do just want to remind everyone that we do have our Advice on Tap session that is this Friday. So if you think of a question between now and then that you'd like to ask us about today's presentation, you can certainly do that by sending us an email or however we need to do that, Tara. But there will be additional time for questions that you might have not thought of yet about today's presentation that you do want answered come Friday. Both Connie and I will be panelists on the Advice on Tap session Friday, and we'd be happy to answer any questions you think of between now and then.
So the last code for CLE is 28. So the code in totality is LE1228.